Let's talk more then about Nandipha Magudumana being denied bail today. Brilliant legal analyst Mpumelelo Zikalala. Mpumelelo, very good evening to you. Always good to speak to you. So the magistrate basically saying there's no doubt, given Nandipha Magudumana's history, that she is a flight risk. Could the court have arrived at any other conclusion?
Yes, it could have. Good evening to you, Mpumelelo, and also to your viewers. I think that's where the mistake is. Remember, when you're dealing with bail application, you're simply saying, is it in the interest of justice that the person be released on bail? Are there limitation or preventive measures that I can implement or conditions that I can state as the presiding officer to make sure that they don't be tried? Now, what you can't do is to deal with the merits of the matter because no evidence has been led. Utterances such as saying that we don't know, maybe you're going to assist the person to escape again, already pronouncing on the innocence or guilt of the accused, alleging any issues of kidnapping, any allegations that wrongdoing would be done, when in fact your job is not to do that as a presiding officer, is one of the federal grounds for appeal, which may be used by Dr. Nandipha Magudumana at a later stage, when if she does take a matter to the High Court. But in the assessment which was done by the court today, I strongly believe that they may have been misguided a bit in terms of the assessment that has to be done in terms of Section 6 of the Criminal Procedure Act, and pronouncements of the innocence or guilt of the accused is what threw the game away in terms of detailing or being clear from my perspective, so to say that maybe you are trying this matter in the correct perspective. The test that you are using is incorrect.
Are you suggesting, Mpumelelo, that on appeal, Magudumana has a good shot at actually getting bail?
Definitely. If you look at it, the only thing which is interested in the main trial is yet to come. That's when you're going to deal with all the allegations which are going to come through. That's when evidence is going to come in. Now, you can't adjudicate the matter and basically indirectly pronounce the guiltiness of the individual where no evidence has been laid in front of you. You can have your insinuation, you can have your presumptions as to how things actually went about, but you can't do that as a person who's adjudicating a bail application. So at the High Court, you may find that the decision is going to be changed, and the High Court may come back and say, we are releasing you on bail. For example, look at how many applicants have applied for bail in the same court, have been denied bail, but however, when they go to the High Court, bail is granted. Basically, detailing or proving that there are higher chances of being granted bail in the High Court than in the Magistrate Court. It shouldn't be like that because the test is all the same. You are reading from the same law, same legislation, same case law. It's just the application which is different, which sometimes I think, as it happened in this case, I think the presiding officers got it wrong.
Well, if Magudumana's own legal team told this bail hearing that basically she left the country not of her own accord, basically that she was forced by Thabo Bester, her accomplice in the bigger case, she was found with multiple passports, we're told, at the time of their arrest in Tanzania back in April. She also doesn't have an address, a fixed address, as we now hearing. For example, what was said was that one of her friends had said, well, I'll take her in if she's granted bail. Those three issues, how much attention would a High Court pay to them if indeed that's the route she chooses to go?
They are important, but most importantly are there preventive measures or measures that you can be implemented to make sure that you are mitigating against the likelihood of those shortfalls being implemented? Let's use a few examples. You can say to her, I'm going to release you on condition that you pay an X amount in terms of bail. I can release you on condition that you have to report even on a daily basis between the hours of 8 a.m. and 5 p.m. at your nearest police station. Don't go outside the Mpumelelo district in which you're going to be saying. If it means that you need to go out and do whatever that you need to do, speak with with the investigating officer so that they know what is happening. Even implementation such as things as ankle braces. There's another legal practitioner that suggested those things. It's something that could be done because what you're trying to prevent by doing or engaging in this whole process, you are saying, I can't whisk away or ignore the fact that you have a right to be presumed innocent by the Constitution. That's a right which generally accrues to you by the mere fact that you've been born. If you want to diminish or take away that right, you must make sure that there are no other alternatives other than making sure that you stay behind bars up until your matter is done and dusted. If there are opportunities in which you can be able to enjoy your freedom while being able to stand trial, make sure that you are able to use it, because our fear or the justice in this case is to say, if you are indeed found not guilty, or if the state would wake up tomorrow a few days before the actual trial starts and then say, Dr. Magudumana, we're withdrawing all the charges, the question would be, how are you going to repay the number of months that she has stayed behind bars? What sort of justice are you going to provide to her? Certainly no amount of money can be able to repay a person's freedom. So in that instance, the balance of all these interests that are there, are then to say, as a presiding officer, make sure that the rights of the accused are preserved as per Section 35 and put measures that can be assessed at the end of the day to make sure that the person will come back and stand trial. Another important factor is look at the track record of the person who's applying for bail. In this instance, you have someone who is a first-time offender, you have someone that does not have any pending cases against it. Then the question is, on what basis do you come to the presumption that the person is going to have a trial when they've never been arrested before, they've never delegated or not listened to a court of law when it's talking to them? All that she's facing now, or what you are basing your presumption on your order, as it was discussed today, it is on information and evidence that has not been tested as yet. And that's where the danger is.
But is that not enough, Mpumelelo, the fact that basically a search party had to be launched to arrest her in a foreign country? Is that not enough basis? For example, her team made much of the fact that they said, well, she missed her family, specifically her children. And when you look at what had unfolded, for example, by leaving the country, she'd have basically left them behind. Even in the previous case, also in Bloemfontein, Magudumanas had basically failed to prove that hers was basically a deportation and that she should be released on those grounds, basically. No, that it was an extradition and not a deportation. So there was also that case, there was a conclusion on that, and then there's this one. So I'm wondering, given the multiple moving parts legally, how clear is it for any court to make head or tail of the situation?
Remember, all that you are dealing with now is allegations. You can't run away from that. No evidence has been led. So if you are going to come to certain presumptions or evidence having been led, it means that you are failing in your duties as a presiding officer. Secondly, a person who is in jail has got legal practitioners who are advising the same way in which I would go to a doctor and doctor would prescribe certain medication. It may be that it was said to her, the best avenue to deal or the best way to deal with this particular factors based on what you are suffering from or any type of harm that you might be facing is to apply during this instance to the High Court. It may have been wrong. In certain extent, I do agree with it. She was supposed to apply for bail earlier on. But it doesn't mean that she must be punished for the manner in which legal practitioners have been dealing with the matter. The law in this case is very clear. Whenever you apply for bail, look at Section 35 of the Constitution, look at Section 60 of the Criminal Procedure Act, and focus on 4 questions. Are you going to commit a Schedule A offense? In order for us to assess that, let's look at your past criminal conduct. That's the only way in which you can be able to determine it. Are you going to evade trial? What type of instruments do you have in order to go away? And what type of preventative measures do you have? Are you going to influence witnesses? Do you even know where they are? What stage is the state in terms of the investigations? Witness statements are provided to the accused individuals well before time. So at the end of the day, you're going to have access to those witness lists and you're going to know what each and every single person says. But it doesn't mean that you are not a perfect candidate to be released on bail.
A quick final one then. Should she wish to appeal, how much urgency would a higher court give to that?
It has been stated a number of times, bail is urgent in its nature. The only thing which is interested in is that as soon as the opportunity has arisen and you have gathered all the information which is required, you can apply for bail. In this instance, go and get the record in which you've been arguing on, go and get the reasons from the current magistrate, and then be able to do your notice to appeal and provide reasons of why you're going to state or the reasons for your appeal. In my case, there would be 3 or 4. First one, you're presuming that I'm guilty when no evidence has been led. Secondly, you have looked at all the incorrect statements and incorrect factors that are not for you to consume at this particular stage. Yes, you may be a court of law, but it's not for you to determine my innocence or guilt. And then lastly, are there preventative measures and certain things that I've suggested and that have been used before? And the answer is a definite yes. So employ those, because all you need to do is protect my legal rights and my constitutional rights per the Constitution.
Mpumelelo Zikalala, good to speak to you. Thank you so much. Legal analyst commenting tonight on the Nandipha Magudumana, Dr. Nandipha Magudumana case today.